Rupprecht Podszun. I'm very happy to have you here tonight. And Rupprecht is professor of law, and he teaches civil law and German and European competition law at Heinrich Heine Universität at Düsseldorf. And he is also vice director of ASCOLA and director of the Institute for Competition Law, ICAT. I'm sure you all know this his blog, which is called PCART, and where he provides updates about especially digital, the law of digital markets. Rupprecht has been affiliated research fellow at the Max Planck Institute for Competition, for Innovation and Competition in Munich. And this is, I met him quite a long time ago, I think in one of his beautiful conferences of ASCOLA in Lecce. Despite this, I want to get into and to melt into things, and therefore to start talking about what we are going to build tonight. So, as you all know, the European Commission has been dealing a lot with what's going on in the digital markets, and the European Commission has been doing so since a long while now. But what is now boiling in the pot is the Digital Market Act and the Digital Services Act, and a lot more, many more things. But we are going to focus on this, especially on these two acts, especially because these are very soon going to be eventually adopted. So where are we? And what are we talking about? We are talking about eventually intervening on the digital markets, and especially on some operators which enjoy especially prominent market power. And the European Commission has been considering whether to intervene with ex-ante regulatory power, because it considers, sorry for the repetition, that eventually competition rules are not enough for the digital age. And after considering whether to update the competition rules, it is now considering to intervene with ex-ante rules. What and should those rules look like? Are we facing a new era where the invisible hand has, let's say, exhausted its function because the algorithms and the technology and big data has made it too fast that the state and the regulators and also individuals cannot actually cope with it, they cannot actually make it so have made it so invisible that actually it is now somehow manipulable. So should the regulator intervene? Yes, no. How should it do that? And especially, to what extent are we going to accept that intervention? And finally, one really final question is, what sort of enforcement powers should there be put in place? I know there are a lot of questions, these are a lot of questions, but there are a lot of questions on the table which have been, let's say, they have been affecting our lives, so therefore now the debate is a little bit more mature, and Rupprecht, together with Philip Masten, have been publishing a beautiful paper for the Konrad Adenauer Stiftung, which has been contributing beautifully to the debate which is going on this topic. Therefore, I would now give the floor to Rupprecht, and I would ask him to provide us with his insights on all of these topics. Thank you very much.
Thank you, Fabiana, and hi to all of you. Good afternoon or good evening, whatever that is in Italy right now, or whatever you would call that. I'm very honored and pleased to be in that course, not least since I'm a big fan of Fabiana Di Porto, and I'm so grateful, Fabiana, that you invited me to this course. And I also learned that all of you are experts in issues like data, platforms, and innovation. So I'm also very interested in getting to know what you think and what your position on issues is. I have prepared some slides, and I will talk you through this. Eduardo, I hope you'll be with me if anything goes wrong. Thank you for hosting me, because I never use Google Meet. We do this stuff with other tools in my university usually. So I'm happy to learn what the big GAFA companies are able to do in these terms, and I will try to share my slides with you. Please, if I start talking, please interrupt me with your questions, with your remarks, whatever comes to your mind, because I think this is a group of, say, 25 or so people we can easily discuss, and discussing is always better than lecturing, in the sense of I want to get you sort of into a thinking mode, and that's what I aspire to. Fabiana, sorry.
Yes, sorry to interrupt. I will, please do write your questions in the chat. I will be happy to take note of your questions, and then at the end of the presentation, I will of course address your questions to Rupprecht.
Okay, if there's anything in between where you think, okay, I've completely misunderstood this, or can you maybe go on this a bit, please don't hesitate to interrupt me earlier, Fabiana. Okay, I think you should see some slides now, is that correct?
Sure, it's working.
Okay, excellent. Okay, I have to see them as well, though. Okay, just 1 second. Okay. So I see the slides now, but I don't see you. I hope that is fine for you. Okay, so first of all, again, thank you for the invitation. I'm speaking now from Düsseldorf in Germany. Let me please just do this little tourist bit, because the people in Düsseldorf have some sort of problem, because we are so unknown, although we are such a great city. And the problem is that Cologne is right next door, and Cologne is very famous as a tourist destination, while Düsseldorf, as you may see on this picture, is such a great place to visit as well. So if we are able to travel again, please come over here to the big Rhine. It's a city of 600,000 inhabitants, and what makes it really special, this place, is that we call ourselves the capital of competition law in Germany, and that's not because of our blog or of my university, but because we have the most prominent courts in Düsseldorf that are located here, that are usually dealing with competition law matters in a central fashion in Germany. That has some historic reasons why that is here, and all the big law firms that are probably also known in your place that deal with competition policy, competition law, they are located here, and their competition law teams typically work from Düsseldorf. So if you don't like to sit on the river and enjoy the Rhineland, whatever, come to Düsseldorf for seeing the capital of antitrust in Germany. That's now final saying on my tourist advertising spot. I also wanted doing some advertising. I know Fabiana not just from that conference in Lecce some years ago and other Ascola conferences, but we also did a book together. And if you do not yet have your Christmas presents, maybe you could consider Abusive Practices in Competition Law. Fabiana, I actually don't know how expensive it is, but I suppose that your students can easily afford. And so it's a good read. I recommend it because one of the editors, the female editor, is really ace, and we have given a lot of care to this project and a lot of nerves as well. So I always think to that, Fabiana, with some, joy and also some nerve-wracking, but that's not due to you. The link is in the presentation. I will hand out the presentation to you, or Eduardo or Fabiana will do that afterwards. So you can click on that. Today, however, I want to talk about something different. You've seen the topic is regulating gatekeepers, and I wanted to sort of discuss with you why and how and what we should do about gatekeepers. And with digital gatekeepers, I am, of course, thinking of the GAFA firms, so Google, Amazon, Facebook, Apple. That is what sort of we usually understand as the leading digital gatekeepers. Some also count Microsoft in, others count Netflix in, or other firms. And having said that, I think it is also important at this point to look into the East, where in Asia we have other companies that have an equal sort of role in the Asian part of the world, or at least in China, with its enormous market. So Alibaba and others that are of such great importance there. My focus today is solely looking into the Silicon Valley and into Europe and the US, since this is sort of where our where we are what we are confronted with directly. I wanted to start with reminding you of this case that you have probably heard of. It's the Google shopping case of the European Commission, an antitrust case, a competition law case. And in this case, as you may have discussed or heard before, the European Commission, led by Executive Vice President Margrethe Vestager, took on Google as the search engine, and actually as a dominant search engine, because they had this suspicion, or they thought that Google was doing what we now call self-preferencing. And how that actually worked is easy to understand, I think, because we all probably are well aware of how Google works. You type in something, this is a commission graphic, they typed in wireless headphones. So if you type in wireless headphones into the Google search, you get a search ranking. And in that search ranking, you get all sort of results for wireless headphones. But at the very top of the list, you find Google advertisements, or Google, some kind of Google box where they lead you to the price comparison portal of Google, which is called Google Shopping. And if you are now looking for wireless headphones, for buying wireless headphones, you are directed, or you are inclined as a customer, as a consumer, to click on one of these top-level advertisements or search results, which lead you to the price comparison portal of Google, where Google then may profit from the sales. And other price comparison portals, like Idealo, a German company, they complained because they were somewhere back on page 4 or 5 of the search list with their offers, and they were not sort of able to get all the clicks that those companies got that are on the first places, and on the first places were Google-owned services. We do not just see this with Google Shopping, it also happens with other fields of Google activity. So Google is active in quite a number of fields, like trying to go into flights, into hotels, etc. And they have the possibility to arrange the search list so that you sort of are directed to where they want you to have. And if they direct you to their own services, this is what we call self-preferencing. And I found it pretty interesting to read the statistics of where Google users click. So if you are not on the first page of Google results, you're completely lost. You have no chance of being clicked. I mean, it's about 1% or so of people who even go to the second page of search results. So the vast bulk of all consumers clicks on one of these first items on the list. And so the Google ranking in the Google search list with Google being the #1 dominant search engine all over Europe with 95% of market share, means either you're on one of the first places or people don't find you if you are in that business. And if you're dependent on these search results, and if you need market access, if this is your prime way to reach consumers, you may easily understand that companies like Idealo go bust and have no chance to compete in the market. So this is sort of one starting point, one problem where we wish to sort of do something about the digital gatekeepers, because some of you may now sort of have the impression that that is not good for competition. If that is sort of all coming from one vertically integrated company, some of you may think that is somewhat unfair if I dominate this and don't let others succeed, sort of. But it's a difficult case under competition terms. It's not like a very easy case to win. And when the European Commission took its decision in 2018, they also earned a lot of criticism for all sorts of various steps in these proceedings. The European Commission fined Google with a 2.4 billion euros fine. I think at the time it was the largest fine ever handed out to a company. They later trumped that with another fine against Google for another in another case, but this is sort of what we are talking about. I don't need to mention probably that for Google, 2 billion euros is not that much. They earn so much and they have so much capital at their disposal, so much liquidity at their disposal that they can easily pay the fine. But sort of that's a different sort of problem of remedying the whole thing. I want to use this case of self-preferencing sort of to take you a bit through the issues that I wish to discuss with you. Now, just as a very quick reminder, what is the field of law that we are dealing with? I take it that most of you have a basic knowledge of competition law, but the course is focusing on many other aspects as well, as far as I've understood. So just let me give you a very quick reminder of the three instruments that we have in competition law. The first is, I always say competition law is very easy because we have just sort of three things to know, basically, or three things that we go against. The first is we go against restrictive business agreements, the classic cartels, based in the European rules on Article 101 of the treaty. And Fabiana has already said that there is a history of enforcing competition law in digital cases, and I've mentioned a couple of digital cases on the right here, so that you see sort of what kind of cases are we investigating here, and just sort of to give you an idea of what restrictive business agreements are. The classic case that we don't find so much with the gatekeepers because they are so strong is classic cartels. So if, say, all producers of Tuscany Chianti agree to raise the price for a bottle by 1 or 10 euros or so, that would be the classic cartel. But we also have restrictive business agreements where competition is restricted on other levels. We are looking into, you may remember the case of the hotel booking platforms. That's probably something or I remember that was a big thing in Italy as well, with the Italian hotels complaining about the practices of Booking.com, where Booking tried to establish price parity clauses so that they always can offer the best price to all consumers that book over Booking.com. So it's all kinds of agreements where someone restricts competition with its trading partner that may fall under this provision, which is subject to competition law. The second point and the second instrument that we use is the prohibition of abuse of dominance, which is the case in the Google Shopping case that we are looking at. So if you are a dominant company and have a market share that is above, say, 50% or so, you are liable not to abuse this strong position, because we want competition on the merits, not based on your strength. And this is a principle that runs through national and European competition law, thinking of competition, say, on the merits, where we wish to see companies competing with their rivals and the customer deciding in the end for the best price and the best offer. The Google Shopping case is a prominent example of this. Another prominent example, speaking from Germany now, is the Facebook data case, where the Bundeskartellamt, the National Competition Authority in Germany, so the German equivalent to the Autorità Garante, I think, where this office targeted Facebook under abuse of dominance provisions, because Facebook abuses its strong position to exploit users on the data level. If you're interested in that case, I love that case. I've been following it from the first day, basically. It's in my view, the most interesting German competition case that has been decided for a long time, and it's still ongoing. So if you have questions on that, please don't hesitate to ask me on that as well. Finally, what we have is merger control. And while 101 and 102 TFEU are provisions that look into cases on the markets where companies have individual sort of wrongdoing that we try to investigate, merger control is a bit different because it is preemptive control of what's happening. So before you buy another company, you may be liable to go to the European Commission, go to the National Competition Authority, notify your merger, and then it is investigated whether this merger would lead to a significant impediment of effective competition. And then the Competition Authority may decide to let the merger proceed or to ban the merger or to put a remedy on this. We have seen an incredible wave of merger activity by the GAFA companies. So Google, Facebook, Amazon, Microsoft, Apple, they've bought enormously many companies, and a lot of the fields they're venturing into are actually fields that they have bought. One of the most prominent examples is Facebook buying WhatsApp and Instagram. So the most heavily used communication services and networks, particularly for the younger generation, are bought by the number one social network, Facebook. And the Instagram merger has not even been investigated by the European Commission because it was not sort of notifiable under the rules. The European Commission looked into the Facebook WhatsApp merger, but they decided that there is no significant impediment of effective competition because Facebook does another job than WhatsApp does. Facebook is a social network, they said, where you share your media, your personal stuff, while WhatsApp is a communication messenger service. And while this is true in some regard, I mean, from a very classic distinguishing of markets, that's probably correct. On the other hand, you now see what happens, everything sort of merging into one another, WhatsApp, Instagram, Facebook looking more and more alike, and a potential future competitor of Facebook, namely WhatsApp, namely Instagram, can be bought without anyone bothering and be integrated in this sort of Facebook universe, with us ending up as having basically one communication network left. And that's exactly what we try to avoid by doing merger control. But the GAFA companies have been unshattered by merger control so far. There's a current case going on, the Google Fitbit case, where Google buys Fitbit, which is a company that does health data and operates in the health business. This may be the first case where the European Commission has meaningful remedies, but it remains to be seen. I think we will see the decision in January, and I'm very sort of eager to learn how Margrethe Vestager sees this. There's a word for these kind of acquisitions. Sometimes they called killer acquisitions. You may have heard that because the GAFA companies kill a company and acquire a company. That's why we call it killer acquisition. That could be a potential competitor in the future. Okay, this may suffice sort of as a very, very basic idea of what competition policy, competition rules are about. And the European Commission in that Google Shopping case employs this Article 102 of the treaty on the abuse of dominance, and if we look at the Google Shopping case, which is sort of the landmark #1 GAFA competition enforcement case, we have a lot of criticism of that. And this criticism, I just want to mention 3 points. There's a lot of stuff obviously disputed in the decision. I mean, if you ask Google, they will tell you, and all the people paid by Google will tell you, okay, this is wrong anyway. You're completely missing the point of what we're doing. We are not dominant. We are not in that market, etc. And just to give you one, I mean, if you doubt that, just to give you one idea, Google, for instance, says in the search business, okay, we are very strong in general search, but people who try to buy something, they don't search on Google necessarily, they search on Amazon and Google. So Amazon is a strong competitor, but Amazon is not a general search engine. So could the market for general search, or is it a specialized market for, say, I'm looking for hotels, I'm looking for wireless headphones, I'm looking for sneakers, whatever? Just to give you sort of one idea where you can legitimately ask the question, is the commission right in assuming that this is the right market where Google is a dominant company? Just to get that idea. I want to mention 3 other things that strike me as being important in this. Even though we have some sort of feeling, or I have some sort of feeling of unfairness in this case, and see that there is something that I don't like about Google doing self-preferencing and being sort of harsh with other price comparison services, for instance, the theory of harm remains controversial. Theory of harm is a word that we often use in competition law to describe what actually is the restriction of competition, where actually is the core of the problem. And this theory of harm is controversial. But if you read the commission case, or that was my sort of impression, you all the time wait for a really decent idea of, okay, what really is the problem? Can you pinpoint that so that everyone is convinced? And even though you have this feeling of unfairness, you somehow have the idea that something's missing in this commission decision, something where they really say, this is why we call this abusive. Because if you think about it, you may always say, well, Google is an integrated company, vertically integrated, that has several things on offer. And if you're an integrated company, it's pretty normal that you try to push your own products, right? I would not be happy if I was an entrepreneur and had to favor products of my competitor. Why should I? I mean, this is my business. What are people discussing about? So you really need some sort of arguments why there is a harm to competition. What is really the problem? And also, if you think of that from a consumer perspective, Google has enormous benefits, and we're all profiting from that, and we all like Google. I mean, you're using Google Meet here because probably it does a good job, right? So it helps in establishing things, and it's so easy if everything is integrated, and you don't have to go to a distinct price comparison portal because it is already in that Google universe, and you can freely float in that without ever sort of going out. You may see that as a beneficial thing for consumers. Yeah. So it remains controversial. The commission was not able to really get the case punching in a way that sort of convinces everyone. The second, maybe even more troubling issue is that the proceedings in Google Shopping took the commission 6 to 7 years before completion. So they investigated Google starting in, I think, 2009 or 2010, and they only came up with the decision 6 to 7 years later. And this decision is not yet even the end of the story, because now Google challenged the decision in the European Court. They may go to the European Court of Justice. So the final result of the case may be there in, say, another 3 or 4 years. And that would make it, in the end, 10 years or so, investigating something in the digital sphere where things do change and where we sort of have the impression that Google may be stronger all the time without a decision coming up, or maybe searching is no longer the issue or something like that. Anyway, so 6 to 7 years for a commission decision in this case, that's really incredible in the sense of this is not how the law can work properly if investigations take such a long time. The third thing is that the remedy in this case does not seem to work. So if the European Commission decides a competition case, what they say is, you're not allowed to do this anymore, please do differently. And they often tell you what to do in more exact terms. And so Google had to come up after the Commission decision, which is enforceable already, despite it is challenged in the court. But the court can change that, obviously. So what the Commission said is, dear Google, please come up with a different solution. And they gave some sort of basic idea into what they were looking at. And now this remedy, many companies say this remedy does not work at all. The situation has not changed for price comparison portals or for other companies that are subject to the vertical integration of the Google services with the Google search engine. And just a couple of days ago, one of the lawyers working for the complainants published a 390 pages document on I've linked to that in our blog, which deals with the question whether it is whether the remedy works, with fantastic graphics on how that does not work at all in Google now. And just today I got the information that there is a complaint by 80 or so companies to the European Commission that this is not working properly. So the Commission does something against self-preferencing, but they're not really able to really tell you what the problem is. They take enormous length of time and they come up with remedies that do not change behavior effectively in practice. Plus, we have no intervention in the GAFA merger cases, so Google can buy whatever they want. Facebook has bought whatever they wanted. And this brings up a question which is really a bitter one for people like Fabiana and me, who are so entrenched in the competition law debate and who are so feverish competition lawyers, namely, is this the failure of competition law? Are we coming to the boundaries of competition law? Is this the end of our possibilities? And I think we have to really answer this question, and we have to sort of concede that this case, whether decided rightly or wrongly, has not worked. And I don't like to see the European Commission investing so much into such cases, coming up with a solution after 6 or 7 years that simply doesn't work. And I don't want to see sort of that something goes on that simply sort of does not bring the results that we built the whole system on. I mean, you're sitting in Rome now, or whatever. Our connection point is in Rome, if I'm right. And in the treaties of Rome, in the very first European documents, you already have these competition law provisions of Article 101 and 102. They were numbered in a different fashion in the beginning, but the ideas or the same wording has been there all the time. But in my view, for the very first time, I think we are sort of coming to a point where we see that our competition laws seem to fail. Maybe that's not the first time. Maybe I shouldn't say that. I'm in my sort of 20 years of doing competition law. So is this the failure of competition law as we know it? That is sort of the question that I wish to sort of explore a bit more with you. We move from competition law nowadays, and this is what our discussion is about, into a different field. And first of all, I wanted to sort of discuss with you or remind you of what actually characterizes competition law, what is peculiar, what is specific to competition law. And I think the points that I mentioned here are very typical of how we deal with it. So I just want to sort of make clear to you what the shift is that we're currently debating and why that is such a shift for you or for us. If you look into now what I would call regulation, I think that you see we are really moving into a different direction now with what the Commission has in stock. And I've called this DSA, that the Digital Services Act. I will talk a bit about that in a minute. But just sort of to signify what's happening, we are moving from ex post enforcement to ex ante prohibitions. We are not just doing specific individual landmark cases like the Google Shopping case, but we take a much broader perception. We go against specific conduct, or we maybe do not go against specific conduct. That's maybe the only thing where I'm still a bit doubtful whether that is a real change. In competition law, we often have a very strong economic assessment, particularly after the more economic approach infected our field. Now we move into the field of per se rules, which is a much more legal concept, where we have stricter rules, where we do not go so much into the economic effects of what's happening. And in competition, we always try to have a more structural approach, so changing the market structure, opening up markets, etc. While in regulation, we have a much broader approach. We may have other goals as well. We may look into privacy goals. We may look into other fields. If we compare these two fields, I think you may think of, say, energy regulation or other utility regulation, water regulation, whatever comes to your mind. And we are now on the verge of submitting companies in the digital sphere to this kind of regulation. And that's a real shift, because so far we have only seen regulation in fields where we were clear that there can be no competition for natural monopoly reasons, say railways, energy, etc., telephoning. Now we are extending several of these instruments to another field. And that brings me to the broader question: how do we wish to regulate these digital gatekeepers? What is the whole idea? And Fabiana has already, thank you for that, introduced the book that I've produced with Philip Marston, or the study that Philip Marston and I did. We are not the only ones. This is a compilation of studies in recent years that has been put together by our colleague Simonetta Vettoso, whom you may know as well. So she has sort of assembled all the different studies where people wrote about how to regulate competition and how to regulate digital gatekeepers, what forms to come up with. And that's an enormous lot of proposals that has come up over the last couple of years. Maybe I should point was one on the reading list. Maybe I should point your interest to the Furman report, where Philip Marston was a contributor, which is the United Kingdom's report on this. It's called Unlocking Digital Competition. You see it here on that slide as well, from March 2019. And I think they were the most radical ones, maybe not radical, but the ones who came up with ideas that heavily influenced the further debate up to this point. And I think it's a good read and an interesting read. If I was to read one of these, I would probably go for that one. I don't want to say that the others are not good, but this is sort of the most influential one, written in this neat British style of doing such things. The European Commission plans to introduce new powers now to remedy the failures of competition law vis-a-vis the digital gatekeepers. So this is where the policy shift takes place. And I want to go into this now a bit. And I introduced several abbreviations. You know that the Europeans always love to work with acronyms that are hard to understand, and if you're taking part in discussions, you better know what NCT, DSA, or DMA mean. We are currently in the consultation process has already taken place, which was a very short sort of exercise. The Commission is now under a lot of pressure to keep going, and the idea is that they wish to present a proposal on 9 December 2020. First it was the 2nd of December, now they've moved it to 9th of December, according to my understanding. And
I'm just sorry to interrupt you, but I just noticed that there are a couple of comments which actually refer to the part you discussed before. When you say that the remedies, especially when you say that the remedies, I assume that this comment by Antonio Manganelli refers to the remedies in to the cases you discussed before did not work. So he is asking whether you could elaborate a little bit more on why those remedies did not work. And then we have a second question asking by Luigi Crimella, asking whether is it possible to imagine an international competition law and eventually under which international commercial authority. Maybe Luigi's question, we can answer to this question when Rupprecht will discuss about the governance structure. While if you could just a little bit elaborate on Antonio Manganelli's question on why the remedies were not efficient.
Okay. Well, first of all, one thing that I want to make clear is I don't want to criticize the European Commission too much for the Google Shopping case in the sense of I don't think that's a bad decision. Let me sort of say that first. But and in particular, what the Commission did and what Vestager did was sort of to push us all into enforcement and to think about this. But now coming to the nitty-gritty details of how do you get the Commission, how do you get other companies into this top-level field, on one of the first rankings, is very difficult because you have, say, 100 people who want to have this place, but you only have sort of limited space, particularly if you think of mobile phones, right? If you think of the screen, you have a mobile phone. So how do you decide who gets up to that first slot? Who is visible on top of the ranking list? And the Commission refrained from giving a very clear idea of what has to be done. So it was mainly left to Google to come up with ideas together with the monitoring trustee who has to sort of assess that. And they came up with models that sort of gave some place to people, but those people had to, I think, was an auctioning procedure that happened, that took place there. And if you imagine auctions, and also if Google itself can compete in this in these auctions, you may see that sort of it remains difficult to get in for many of them. It remains difficult to the auctioning process may be sort of structured in a way so that specific companies lose out or do not lose out, etc. So Google still has a lot of sort of leeway to decide on who's up on top. And for the technical details, I really recommend to look into this report of Thomas Höppner. I can send you the link if that's of interest to you. Of these 390 pages, there's an executive summary, don't worry. But sort of, and it shows us how enormously difficult it is to put that into practice, because you are always dependent on algorithms, on data, on things that we basically don't understand, right? I mean, we are not in the position of Google knowing what's exactly happening. So that makes it so difficult to deal with that. I think the other question I
think you already answered also the other question by Carmela Mendrino, who is a student of the Big Data course, and thank you for that. So please, thank you for going on the NCT, DSA, DMA acronyms.
Okay. Just to get the names, or just to give you an idea of what we're talking about, NCT is the new competition tool. The DSA is the Digital Services Act. The DMA is the Digital Markets Act. I will show you in a minute what it means more practically. Just sort of to give you the update, the Digital Markets Act seems to be the Commission's proposal integrating the Digital Services Act with the new competition tool. So we often discuss this as the DSA and NCT. Now it seems to be the DMA that comes into play, because it sort of integrates that into one legal act. And there is an interesting part behind this, in the sense that we always wondered, why would the Commission now come up with what we call DMA, and it seems to be with the competences, it seems to have to do with the competences of the European Commission. The European Commission is not, cannot just act like they wish. They always need sort of to have the powers for that, and they seem to want to put this under. This is now for the law guys of you. They seem to want to put this under the digital under the internal market competence framework and not the competition framework. So because for competition, they would need unanimity of all member states, while for internal market, they can decide by majority. And now they seem to try to move the new competition tool into internal market stuff so that they don't need the unanimity of all member states. That's just sort of my suspicion why they're now talking about the DMA. If they propose this in December 2020, and if they come up with a legislative proposal, this would mean that probably we don't see that in action, but for another 1 or 2 years. So personally, I expect all these powers that I'm now discussing, or the ideas we are now discussing, they're becoming effective in 2022. That's my sort of understanding of the legislative process in Brussels and Europe. Okay, now first of all, let me just quickly introduce these to you, and then I return to that at a later point of the presentation. What is the NCT, the new competition tool? The new competition tool means that the European Commission may look into markets, investigating markets, and intervening into markets without having found an infringement of rules. And that's something really, wow, right? So you have an authority that may look into markets, and they may say, okay, you have to do this and that, and we, even though you haven't done anything wrong, you may have to change things. You may have to divest parts of your business, for instance, and that's a pretty stark contrast to what. I mean, in my German legal understanding, and probably also in your Italian legal understanding, would be the normal way. Someone does something wrong, that's why we have an authority stepping in. When the Commission put that up for consultation, they weren't sort of asking whether this is a good idea at all, but these were the questions. They put up 4 options, and that was quite interesting, I find, because they framed our discussion very strongly, not in the sense of, do we want that at all or not? Is that even legal, or can we do that with the rule of law, etc.? But what they were asking was, do we want that based on dominance, or do we want it based on the market structure, the new competition tool? So can we step in just if there's one company dominant, or do we need sort of certain features of the market structure that need to be there before we can step in with such a new competition tool? And secondly, should we have this tool for all sectors, or should we have this tool for digital markets only? And these were basically the options that were given to the public for consultation. So not the question whether we need that at all, not the question how we can sort of put that into a legal need framework. I'm just mentioning that for sort of looking into the political framing of the thing. Now it seems that the Commission tries to restrict this to digital markets, although all experts and everyone in the consultation said, please do that for all sectors. May well be possible that the postal services or the car makers or whatever falls onto that. But the Commission now said we want that under digital, only for digital, and that has to do with the competences problem that I mentioned earlier. Discussing the digital, sorry.
Antonio says that sounds very much like a legislative power. It means much an ex ante power, much more than an ex post power. So it doesn't matter really whether antitrust powers are effective or not. We just do intervene.
Yeah.
Full stop. Ex ante.
I mean, it's not ex ante. Sorry, it's the ex ante part is, as the Commission, you probably have a good idea of what you want to achieve in markets, but it's not ex ante because you do the investigation before. So there is some form of investigation and some form of finding needs to be there. So you probably cannot just say, I mean, there's no finding of where someone violates the law, but there probably needs to be some economic finding in the sense of this market doesn't work properly.
Okay, could we equate that to a sort of impact assessment?
Yeah, I think that's a good word for that, in the sense of we see in these, I mean, what the Commission tries to remedy is that we see these enormously powerful companies like Google, Amazon, Facebook, Apple, and they don't know how to sort of, they don't find the theory of harm under competition law that really can sort of help the problem. But they see there is a problem. They don't want companies sort of having these ecosystems, the walled gardens, etc. They don't want them to sort of dominate all sorts of business, and that's why they sort of wish to come up with something else. And they see this has an enormous impact. They can assess the impact, and they can then say, okay, we have to change that. But they don't need the barrier of we have a real violation. Okay, I move on to the Digital Services Act, sort of for introducing this. The Digital Services Act has two pillars. One pillar is a revision of the e-commerce directive, where you have things like who is liable if you buy your goods on, say, Amazon, and should you sort of should Amazon pay for liability or not? So that's sort of all sorts of contract law, commercial law issues that are relevant for e-commerce. That's the pillar that I don't sort of engage with here. The other pillar is the ex-ante regulation of platforms, and here we are really into it, ex-ante now. And what the Commission tries to do is to give more precise, more specific per se rules that companies have to follow. So there will be stricter rules for digital gatekeepers, for platforms, whoever is exactly targeted, on how to conduct business. And they, in this consultation process, they presented essentially three proposals. First was, we simply revised the P2B regulation. We'll discuss that in a second. Secondly, we need a regulatory body at the EU level to collect information. So just information collection, no rules yet. And three, we need a new ex-ante framework for gatekeepers. So notice, for gatekeepers, not for all platforms. And this may come with a list of practices that are prohibited per se, so a blacklist. Those of you who have looked into unfair commercial practices, for instance, in the Unfair Commercial Practices Directive, we have such a blacklist in the end, where it really says, okay, if you run a business, you may not do this, you may not do that, you may not do that, in very concrete, exact terms. And my understanding is that we are now, the Commission is aiming for this option number 3. We set up new rules for digital gatekeepers, telling them exactly, you may not self-preference, you may not indulge in self-preferencing. If you do rankings, you have to do this and that, etc. And this is sort of a real shift, because we don't look exposed into what they have done in the past, and we don't try to give them remedies sort of with which we try to keep markets open, but we tell them ex ante, this is what you're not allowed to do. You have to do, you have to align your business with this and that points. Just to give you an impression where we stand at present, we do have the platform to business regulation. That's the regulation EU 2019-1150. So that we already have some rules for platforms, regulating platforms in the EU. And this regulation is all about transparency. So it does not have any, I don't know, does it have any? I'm not sure, but all the relevant norms are not prohibitions, but they provide transparency, or force you to provide transparency. I've given you an example here that fits to the Google shopping case. It's in Article 7.2 of the P2B regulation. The regulation is applicable to platforms that host businesses like Amazon on its marketplace. So Amazon does not just run, as you know, its own retail services, but it also offers a marketplace where you as a retailer can engage. And it also addresses search engines like Google. And I've put up this rule here just to give you the impression how that works. Providers of online search engines, so read Google, shall set out a description of any differentiated treatment which they give or might give in relation to goods or services offered to consumers through those online search engines by, on the one hand, either that provider itself or any corporate website users which that provider controls, and on the other hand, other corporate website users. So what they say in this rule is, if you are Google, you have to describe how you treat your own businesses and the businesses of others differently. So if you do self-preferencing, if you do differentiated treatment, you have to tell people about it. You have to provide transparency. If you look how these companies actually deal with this in their terms and conditions, where they set out, yeah, we do some differential treatment, that's really incredibly vague, and you cannot read a lot of that, and it's only transparency. So if you know that you're cheated, or if you know that you have no chances on Google, that doesn't really help you a lot, but okay, you at least know about it. So this is where we currently stand in Europe. Yeah? And now the Commission ventures into the Digital Services Act, where they revise this P2B regulation and come up with a list of blacklisted practices, for instance, forbidding that you treat products of others differently from your own products. Now, this is the point where we are currently standing, and we don't know exactly what's going on or what's coming up. And so what Philip Marston and I did was to write this study. If you can see me, this is the original one here that I'm holding into the camera now. So what we did was to write a study for the Adenauer Stiftung that you introduced earlier, Fabiana. The Adenauer Stiftung is a think tank in Germany that is run by the conservative party, the Christian Democrats in Germany. And I always found it stunning that the conservatives in Germany, who are seen as a pro-business and anti-regulation force in politics, turned to Philip and me saying, can you please give us an indication of how we can restore balance to digital competition, what we can do about the gatekeepers. And I thought, is that still the pro-business conservatives that I sort of know of, or are you now the pro-regulation company? And I found that stunning in Germany. I don't know how that situation is in Italy, but actually all parties of the political spectrum from left to right are now very strongly engaged in targeting the digital gatekeepers, the GAFA companies, actually. And
well, I don't know how the situation is in Italy, because I've been living in Israel in the past year. So I think the question should be turned to the other Italian guests. So I'm now living in Italy, of course, but I still don't have the I don't know the real taste of what is the situation here. I can tell you that in Israel, there is not much support in favor of ex-ante regulation towards digital platforms, and I would rather say that quite to the contrary.
Okay. My impression is, I don't know whether anyone of you wants to add on the Italian political discussion.
Oh yes, please do. So if there is anyone who wants to intervene and to tell us maybe on the Italian situation, please go ahead. Briefly, of course. No one? Okay, so please.
I mean, interesting, maybe just sort of, if we're looking at that from a political perspective, I mean, the interesting thing is probably that the companies we are targeting are all American companies, basically. So they're not so many European successful platform providers, but Spotify maybe, and Spotify has already also moved to New York with most operations. Sorry, Olga?
Yes.
Sorry, I had my microphone off, and I tried to do something, to say something about the competition in the digital world.
Please go ahead.
I'm trying to be quickly. My impression is that there is a strange approach, because we can see the big high-tech firms that they, with long delays and fines, that are a tolerable cost of doing business for tech firms. For instance, Facebook that took over WhatsApp. And in this point of view, do you think that it's necessary that the legal frameworks need to be updated, maybe under the model of the Germany, with when they tried to modernize it for the digital age?
Mm-hmm. Yeah, I think this is
the citizens forcing incumbents to share some of their data, or at least making it easier for users to switch easily between platforms. Thank you so very much.
Yeah, I think this is now really turning us to the point that we are sort of trying to discuss with you now, namely to what are we heading for? And I've told you in the beginning that my impression is that we've reached the limits of our current competition law system, and actually I personally, even though I'm critical of some of the stuff, as you may have heard, I personally very strongly am in a pro-enforcement camp, if you may call it like that, and I do think, yes, we need some additional rules here. And if we discuss this, I always think of something that Margrethe Vestager said in a discussion. You may click on the link once you've got the slides. I don't want to try my luck at it now, but Margrethe Vestager, who's an inspiring figure anyway. I mean, she's an icon in this field. She tries to put the whole discussion into a much broader sort of dimension. And I think this is important if we sort of discuss how the legal framework what the legal framework should look like. In the past 20 or 30 years or so, we had a very strong economic focus on things, particularly influenced by US and UK academics and enforcers who put a lot of emphasis on economics and on consumer welfare. And consumer welfare, in their understanding, essentially meant you should not pay more than you have to pay. We look into the costs, and if a merger leads to, for instance, significant reductions in costs for the companies, that's fine, right? And now what Margrethe Vestager put forward basically was, this is not just about economics and not just about consumer welfare, but we have a broader idea of, or we should have a broader idea of what should the world look like that we wish to live in, right? And this is the interesting thing about the digital gatekeepers, in my view, that Google, Amazon, Facebook, Apple, etc., they influence us so heavily, not just in economic terms, in competition terms, but beyond as well, because we get our information from them. We structure our world according to them. If you buy an Apple iPhone and a Mac, you're completely dependent on the decisions that Apple takes for you, right? And you're sort of set on their predetermined paths. Google steers our information, etc., etc. So, as Vestager said, it is about the choices we make, about how we shape policy in this age, and that is something new, and that is something where we have to take these decisions. And this is, Olga, your question basically. Do I think that we need an update of this framework? My answer is yes, I do. And I do not just think that because we have problems in competition that we currently cannot regulate because our exposed competition proceedings are problematic, but we also need that not just beyond economic terms in saying we have a political task to sort of shape the world in a way that we see as fit. And I have three principles for shaping competition and for shaping the policy in the years that I try to put forward. And these three principles are the following: the freedom of competition, fairness of intermediation, and sovereignty of decision making. Let me just very briefly say a word on these. Freedom of competition seems to be, for me, the most obvious one. We do think that markets work properly and work best if they are regulated by competition. This competition should be free. So if there is monopolists like Google and search, and or if you run the App Store on the iPhone or the App Store on the Google phone, the Android App Store, then you are liable to ensure that some form of competition is still possible. So you have to ensure free competition. For me, that's the obvious one, and the one where all competition lawyers actually agree. The other two are more controversial maybe and are stemming from different fields. Fairness of intermediation. What I'm thinking of here is that in many of the cases that we look at, these platforms act as our representatives, as our agents, as intermediaries. And they use this power of intermediation, not just for the consumer, but also for the other market side. So they are working on both sides. And they are sort of bringing together both sides. Google, for instance, brings together my interests as a consumer and the interests of the other side that tries to make me open their website. And they are acting for both sides as basically agents. Same does Amazon with its marketplace. And if you are representing someone, if you're acting as an agent for someone, you have to be fair with that person. And if you're acting for both sides, you're usually running into an abusive situation, and you may very easily abuse this power. And that's something that I fear very much. And that's where I think we need fairness introduced in that, so that the intermediary in the middle, Amazon, for instance, for consumers and retailers, may not abuse its position and needs stricter control and stricter rules. The third
can I just abuse my moderation powers to step in the fairness question?
Sure.
Very often, if not always, the intermediary powers of digital platforms are exercised through algorithms, therefore requiring, of course, there are business strategies behind. However, the way those business strategies are implemented is algorithmic, in the sense that once the algorithm that is behind, that is used to by Google search, of course, is not every time instructed by a natural person. It is just an algorithm that is instructed every, let's say, 1 week, and it goes by itself. So when we ask for fairness, and we want fairness to be somehow inoculated into business strategies, we are somehow asking algorithms to be fair. How would you legally require an algorithm to be fair, to behave fairly?
Can I return that question to you, Fabiana?
Absolutely.
You're more knowledgeable than I am in controlling or
definitely
by design, etc. So I think I think this is a ace question. You are the expert on that, and you probably have much better answers than I do.
Okay, I will answer at the end. We can share the answer then.
Lucky me. I fully agree that this is sort of an essential question that we need to, where we need an answer to. Yeah. Let me quickly turn to the third principle that I put up here. It's the sovereignty of decision making. And that is something that I found very interesting because I see it so strongly in this German Facebook user data case. And I think this is directly linked to data as an issue in this regard. Because what my idea of this is that individuals like you and me and everyone, we should be the ones calling the shots, in the sense of we take the decisions in the economic sphere, also in other spheres, and we should not delegate this decision to others. And this is sort of the big danger that I see in digital ecosystems or walled gardens, that you are put on a path and you basically have no decision-making room left. You either take it or leave it, either you are in or you are out, but if you're in, you have no power of decision left. And that is, in my view, something that goes very strongly against constitutional values of self-determination, of having a significant say if you deal with your own personal data, but also as an economic principle. I mean, if those of you who still remember Friedrich von Hayek, the Hayekian approach to competition, you may remember sort of that competition and the business world actually depend on people taking their own decisions. and not people being sort of having taken their decisions away from them, their decision-making power, handing it to others. And if you are engaging on Amazon Marketplace, if you are using Apple, for instance, you're very strongly predetermined by these companies. And I think this is a real danger and a real problem. And I see that conflicting with the constitutional value, with the general principle of sovereignty of decision-making. And the Bundesgerichtshof, the German Federal Supreme Court, valued that highly in the Facebook data case. Okay, now from these principles, we need to have rules. And I know this is sort of now something where you probably can all jump up and ask questions, and I cannot answer these questions, just stating that at the outset. We need per se rules. That is sort of the idea of ex-ante regulation. These rules should follow the principles, but the rules need to be there and need to be very specific. For instance, saying, okay, you need to offer your services in an interoperable way, or you need to be open for multi-homing. You may not restrict the freedom of your participants, of your consumers, of the businesses on your platform to engage on other platforms. You need to be neutral if you present your search results. You may not discriminate against others. You need to offer a real choice to users whether they present their data or not. So these are all sorts of examples.
I'm sorry if I interrupt you.
Yeah,
I'm sure that I have warned you about the fact that our students come from very different majors. And some of our students do also come from psychology majors. And Atessa is suggesting that algorithms in the final form are generated by our choices, in the sense that they are trained on data that are actually our traces. So therefore, they do reflect also our choices. So I guess she guesses that in the end, it's all in the hands of us as consumers, just like in the psychical marketplace. I guess she wants to say that, or physical, or maybe psychical. I don't know what she means, but I think she has some point.
Physical. I'm sorry, I misspelled it.
Physical.
Okay, I find that a very interesting point, and I find that a very interesting point, Atessa. And I maybe two remarks. The one is yes, or three remarks. Yes, you're probably right, but still, my understanding of using algorithms is that that the company employing the algorithm still obviously can put some sort of determination into it, how they make their profits. I mean, they maybe use our choices, but or our traces, as you put it, but they are still sort of able to direct our choices into the direction they wish to sort of see. So there is an element of, it's not just us, it's also them sort of influencing the algorithm and the path. The second thing is, I don't want to be reduced to my historic traces and choices. I mean, this is sort of something that characterizes me and you and everyone as an individual, that we're sort of free to take new steps, different things, be curious for other stuff. I mean, I always think of the Amazon algorithm telling me once I've bought one book by one author or one, they think I will for the rest of my life read these books, right, by this author and not read something completely different. So this historic choices has some danger of sort of reducing our way of seeing it in my view. And the third point is, and you're probably a much better expert than I am in this, is the question, how free are we to sort of, or how much, or what is the point of algorithms and choices offered to us, etc., influencing our behavior? Are we sort of, is it the same thing if I'm standing in a supermarket and the supermarket offers me a shelf of things where I can sort of choose from, and they place one product in the middle of my eye level view? Is that the same? I have a search engine coming up with a result that knows, okay, he always buys this product. I will present this product in the first 5 things. I mean, what I completely sort of agree with, I think this is something that you would agree on, Tessa, is we need psychologists and we need consumer behavioral studies to devise these rules and to know exactly what we are discussing and talking about. And we have a huge lack in this in regulatory theory and in competition law. I mean, we haven't really done a lot of consumer behavioral studies in the past. So psychologists need to go into the field and instruct us and inform us. And my view would still be we have a choice that we can make, and this choice must take into account that we are free thinking, freewheeling minds. Does that sort of answer your point? I hope so. I'm not sure. Yeah.
Yes. I think it's actually you are right, but I think it's actually kind of funny how do we settle on the choices they gave us. I mean, it's always in our power to choose to go. Okay, let's say I'm shopping for a Hoover, right? So Amazon shows me different Hoovers, but always in my choice to go and not settle for the first 2 pages or for maybe the Google result, the Google shopping results. I mean, the power is in the consumer, but what happens, I think, in most of cases that we settle. We just, okay, fine, I just need to solve this problem. They solved the problem for me. So that's what happens. We want to have to resolve things fast, quick. I don't want to spend 5 minutes searching for a Hoover. If you gave me the first Hoover, I look at the research, I see the reviews, I see, okay, great, this is 5 stars. Okay, fine, I'm going to buy this one. So it's actually implemented on us. Also, I think also for the future artificial intelligence, these are all data that they store, right? So it was interesting. Last week we had a discussion with another professor about how CAPTCHA codes always show images from the exterior, and that discussion was they do that because they need to program artificial intelligence for self-driving. So that was an example of how we settle with our choices, with what they choose for us, if you can see.
We are training the artificial intelligence. So we are the different boxes. Okay, so Antonio Manganelli is telling us that the multi-homing is especially relevant because we move on, especially when we move, thank you, Atessa, especially when we move to information markets. Algorithm efficiency is definitely impacting pluralism, which is by definition to be exposed to something that is different from us. So we need to be proposed as something we would like to be proposed. We wouldn't like to be proposed, or even we would like to be proposed. So, okay, thank you. We can move.
Yeah, thank you. Thank you very much for these really good comments. And I think both comments by Atessa and sorry, I forgot the other name already.
Antonio.
Yes, thank you. What both of them really point to, in my view, is that Antonio, sorry, yeah, I see you now. What both of you point to is these are hard choices that we have to make. I mean, do we really want to step in with consumer benefits with our nice world, and do we want to say, okay, you may not do that, or you may not? We force you not to forego your data and your decision-making power. And I would say, yeah, maybe we have to take consumers out of their comfort zone and tell them they need to do differently. And I think the same is true with the information markets that Antonio alluded to, where we currently see how that sort of influences democracy and our capacity to build our opinions, etc. But if we wish to change that would probably really entail very, very strong and hard changes and tough choices that we have to make. And I fully agree with you that these are our incredible problems that we need to turn to. Maybe just very briefly, we can come up with rules, say, for self-preferencing. What is completely open at present is how do we design this rule specifically? How do we deal, for instance, with the questions that Fabiana brought up in the sense of what if that is algorithms? Where do we, at what point do we step in? At what point do we regulate? How concrete do we get? Who is targeted by the rules? That's another question that is currently very heavily under discussion. And what are the sanctions if someone violates the rules? Because all this is currently in the political debate. And you, as people particularly interested in this field, please voice your points to the European Commission or to the people representing you in European Parliament, because they are all on, they really not yet decided on this, it's my impression. So they're really looking for input, for ideas. How can we frame that? Whom do we really want to catch? And I find that very interesting if I follow this discussion, for instance, that obviously Google is not such a fan of the Digital Markets Act, but a company like Booking.com, which is also a very influential platform, says, yeah, the Digital Services Act is what we need. We want that. And then I always turn to Ben Schroeder, who's the Booking.com competition lobbyist, and I say, I mean, you are the next target. And he says, no, we are not. We are not like that. We are different. And this will not be binding upon us. And I always think, okay, good luck if you believe so. I'm not sure whether there should be a difference between Google and Booking, but maybe we have to draw a difference between Google and Booking. And what is with, say, a new and upcoming platform? How do we deal with them? Philip and I came up with, I've skipped this slide in a second, with a sort of sliding scale of enforcement where we would say we have to do different sanctions to different platforms for different behavior, etc. But I wanted to turn to another point that seems to be more interesting maybe for you. I'm pretty sure that you've also dealt with the General Data Protection Regulation, the GDPR, and the privacy rules in this regard. And I wanted to briefly look into that and maybe also ask for your opinion if you're knowledgeable in this field, because Philip Marston and I, for our study, we have thought about, okay, if we now need to design such a new framework like the Digital Services Act, what are our parameters for coming up with mechanisms and enforcement, etc.? And the one thing was, where we were pretty clear, was we need to involve the national authorities and the market actors. So the companies need to have a big say, the national authorities need to have a big say. The European Commission cannot do all that alone. That would be wrong and problematic, and they will never be able to cope with that. The other thing is there are different directorates general in the European Commission where we thought they really need to work together. That doesn't work at present very well. So they need to get their act together in Brussels so that it doesn't end up in a real chaos. And one thing that we also discussed, and where we put up a couple of lines in our study, maybe you've read that, is that we want to learn from the mistakes that have been made in privacy regulation with the regulation of the General Data Protection Regulation. And I don't know whether you sort of share this criticism or how you see that, because it seems that some of you are very good in this field. But our impression was that the GDPR has, while being a fantastic act and a legendary act already, it has a lot of weaknesses. And we need to, if we discuss how to come up with new rules for competition, for instance, we need to avoid the failures and mistakes that the GDPR did. Let me give you the points that came up to our mind, and maybe if you want to share your view on that, I'm very happy to hear that. First is, consent is useless. You get consent very easily from people. If you offer them a carrot, you easily click on, yes, I agree with basically everything. So the key principle is not so helpful. You need stronger prohibitions rather than people giving away their consent to what's happening. Secondly, it seemed to us that the big established players like the GAFAs, who already had collected their data at the point when the GDPR came into force, were privileged in the sense of it's much more difficult for everyone else now to sort of come up with meaningful data, because they have already their established base of customers and of data. Thirdly, compliance costs for small and medium-sized enterprises are out of proportion. There was a discussion that we saw at the beginning of GDPR entering into force, that SMEs said, oh my God, we don't have a legal department, we don't have data experts in our company. Now we need to watch out and we need to employ people, etc., just to take care of compliance with GDPR requirements. Fourthly, enforcement, at least in the beginning of GDPR, was lacking and maybe not as tough. This seems to have changed already a bit. So there seems to be more meaningful enforcement action on the GDPR. But enforcement is also very diverse because there is no unified, harmonized enforcement system in the EU, where Germany has a completely different data enforcement system than other countries have. And it seems to be that it very much depends on the institutional setting in different countries, whether you have meaningful data cases or not. The final 2 points are also very important to us. When the GDPR came into force, we had discussed the GDPR for approximately 5 years. So it had been in the making for 5 years, and there had even been 1 year, just the year before entering into force of GDPR, where we hadn't even modified anything. It was just sort of lying around on the table, and before entering into force there was some period for adaptation, etc. But that also means that later developments are simply not included, in the sense that we haven't been able to follow what's happening. Although there happens such a lot with data, the GDPR is now on the level of our thinkings of, say, 5, 6, 7, 8, 9 years back. And final point here, it is so difficult to open this up again because the regulatory process in Brussels, the legislative process, is so complicated that no one is inclined to say, okay, maybe we need to introduce new rules for digital gatekeepers and their use of data in digital ecosystems in the GDPR. So let's change the GDPR. This is not how things work in Brussels, because this would mean, okay, we invest another 3 or 4 years into this before we get to something. So this is sort of something now on a more legal, on the level of how do we actually push forward if we want to regulate things, where we had the impression that the GDPR is a good example on the one end, because it is a model approach for regulating privacy. On the other hand, it has significant weaknesses that we need to avoid if we now move into the field of regulating gatekeepers. I don't know whether someone of you wishes to say something on that, or whether we are on the wrong path here, or whether you agree with that.
Maybe you can switch off your mic, please, otherwise we have echo. Thank you. Atessa adds that although there is the legitimate interest rule under the cookie section, most websites still collect the data under the cookies rule. Yeah, this relates to your last point, maybe.
Yeah, absolutely. Yeah.
Sure.
So I have very few slides left. Maybe I just keep on going and then we can discuss other things in the remaining minutes. Okay, what I wanted to show you here, I'm so proud of this slide because I designed it, but I don't want to discuss this with you too heavily, because I think this is now really for the connoisseurs of competition enforcement and etc. So just sort of to give you an idea of what Philip Marston and I came up with, how can we now go on with effective enforcement? We need to keep enforcement of Article 102 in the merger control regulation, but we also need market investigations and we need a strong enforcement mechanism for the Digital Services Act. This is our proposal. This is not what the European Commission might have in their sort of thinking, but just sort of to give you an idea. If you want to go into this in more detail, just sort of look into our study. I think that's not sort of the turning point for this. Just sort of one more sentence on the new competition tool, because that is so incredible a tool. I told you already that the new competition tool is designed as a tool for investigating markets without a suspicion of infringement, bringing everyone to the table. And at this table, we come up with remedies for companies and also for government without one of the companies doing anything wrong. And this tool is employed already in the United Kingdom, in Britain, by the Competition and Markets Authority. And I brought you an example here that I find very interesting, because it shows us what this would enable to do. It is from the market investigation in airports in 2009. And this is the summary of main conclusions from this 2009 report of the UK Competition Commission. They are now called Competition Markets Authority, the Airports Market Investigation 2009. That is sort of a model for what the European Commission is now thinking about. And what you see here, if you read the passages that I've highlighted, is the Competition Commission has concluded that BAA, that the British airports owner, the common ownership of airports in southeast England and lowland Scotland gives rise to adverse effects on competition in connection with the supply of airport services. So they say, since BAA owns all the airports in southeast England, which includes London, we have adverse effects on competition. Adverse effects on competition is nothing that is legally wrong. That's just an economic finding, right? Now, what they say is, jump to number 2, the Competition Commission has concluded that a package of remedies would be effective in remedying the AECs, the adverse effects on competition identified, namely the divestiture of both Stansted Airport and Gatwick Airport to different purchasers, the divestiture of either Edinburgh Airport or Glasgow Airport, etc. So what they said is, you didn't violate the law, but there were adverse effects on competition by you, BAA. Your company owned too many airports. And so we think it would be best if you sell Stansted Airport and Gatwick Airport and Edinburgh or Glasgow Airport to others. And that's what happened. This is actually what was then implemented. BAA sold Stansted and Gatwick and I think Glasgow, I'm not sure whether this was Glasgow or Edinburgh. So they did that. And now if you think of this tool in the hands of the European Commission, you may see where this ends. We sit around a table, we do a 2-year investigation, and in the end, a market investigation team employing the new competition tool says, the Google search engine produces adverse effects on competition, and we have concluded that a package of remedies would be very helpful. Maybe Google has to divest all its other services and may only now do a search engine, period. And I mean, if you see this tool in the hands of a competition authority, that's just wow, right? So that brings up the discussion. And also someone asked earlier on data sharing. Of course, you may not necessarily need a divestiture of Google, but maybe you just say it would probably help competition if you were opening up all your data to others. And this is the tool that is probably much more effective than everything that we've currently in the law. One final note, regulating the digital gatekeepers that I've now presented to you is not the only necessary thing for shaping the world we live in. Maybe it's not even the most important one to shape the economy and our digital future, but it is the one that I focus on here. But I think that the discussion and the whole dimension of this is much broader than only focusing on the GAFA companies. I'm thinking here of, say, things like innovation policy, technology, disruption, data, education of people, our digital literacy, etc. And I think we should always be aware when we start into our fantasy and our creativity and regulation that this is only a small part of the world that we wish to live in. Thank you so much for listening all the time. I'm very happy to answer more questions, and I also invite you to follow me on Twitter and obviously in the blog Descartes, where you see a lot of these things as well. Thank you so much. Fabiana, over to you.
Thank you, Rupprecht, for this wonderful presentation and for all of these insights. I don't want to take too long to thanking you for your speech, which was really, really great. and I just want to open the floor for discussion. I have plenty of questions, but I want to refrain and open the floor. I have a question which relates, I think, to both our legal system, meaning our as an Italian legal system and the German legal system. In our constitutional legal system, we do have a norm which is Article 42, which actually allows, well, actually we have two norms, which are Article 41 and 42, which especially Article 42, which relates to property, but also Article 41, which relates to liberty of enterprises, both allows for expropriation. I know it is not very nice to talk about that and is outdated, but I know that there are some legal scholars who are actually thinking of it and to somehow link to the idea of using norms that are based on the fact that when there is no possibility, other possibilities for exercising individual rights as citizens, then using one and only one facility, then there is also the possibility of proceeding with the expropriation of that right. So is there anything similar in the German legal system that would also authorize such an extreme remedy or not? And would that, of course, this is just an intellectual exercise, but I know of jurists who are actually with some legal ground reasoning around this possibility, even in the digital world. Is there anything similar in Germany?
Yes. In the Constitution, we have rules that are similar to what you've mentioned. I don't know of any case of recent years that has been decided on that basis. I mean, it happens if you build a motorway or something, right? And your land is taken away from you, but that's probably not the situation that's not similar to the situation that we have here. Two things come to my mind. The first is, I am very skeptical that such sort of expropriation does work if it is confrontational, because the legal proceedings, the legal hassle that would be attached to that, the compensation to be paid. I mean, if you take away property from someone, you have to give something in exchange. That's probably taking us years and years, and in the end would be very problematic. There is one case coming to my mind now that I said, I don't know of any recent cases, but actually we had a recent case in the nuclear energy field, where Germany decided after the Fukushima tsunami to get rid of nuclear energy in Germany. And now the companies that had nuclear plants, power plants running, sue the government for damages, and were successful with that now in the Constitutional Court, which means it's an enormous challenge for Germany to pay them for this kind of expropriation, making their property of nuclear power plants useless. So if there is, I think in the digital world where things are moving fast, etc., doing this on a confrontational level simply doesn't work. If they agree, as in the airports case that I presented earlier to you, where the company BAA in the end said, yeah, okay, I'm happy with that, let's do it. I get a lot of money for that and I'll invest that in other fields. That is, there you can do it if you agree on that. Now, speaking in this course, what comes to my mind in this regard is sharing data as an obligation. I mean, this is also a notion that somehow has to do with property and or with I mean,
yeah. But sorry, I probably forgot to mention that expropriation would be a last resort remedy in case of companies that would refrain or would say, no, I'm not gonna share my data, even though I am actually obliged by the law to do so.
Oh, okay.
So is there anyone who is actually considering to use expropriation as a last resort remedy against those who would not consent to share their data? In case, of course, of super dominant with no monopolist.
I'm not really aware of such discussions over here. Yeah.
Okay, and what do you think about it?
I think the data sharing issue, I mean, that seems to be vital for very many purposes. And personally, I'm very happy with obliging companies to share more data. The problem, I mean, the point is the follow-up problems or the follow-on problems after that are so incredible. Like, what do you do with personal data? If they are you able to share? What about IP protected stuff? What about your business secrets, your know-how, etc., etc. And then, of course, the issue of compensation, because in my understanding, if you have put some value into it, you have to get something in return. Then, of course, you have the question: what kind of data status? So do you take the raw data, the raw material, or some kind of processed data that you have to share? In what format, in what frequency, etc. So there are thousands of problems attached to that. And in my view, there is no way in answering that on an abstract level, but we need to foresee procedures that enable us to solve these problems very smart and very quickly in individual cases. And you cannot go to a German court with that. If you go to a German court and, I mean, you can legally, but if you go there, you get a decision in 2 years. And this decision is then telling you, okay, please go back to the negotiation table and try to come up with a solution yourself. That doesn't work, right? So the court system in Germany, which according to my humble knowledge is not completely inefficient, but it wouldn't work in these cases. So in my proposal is always use something like ombudspersons, so a quick remedial, maybe sector specific body where you can turn to and say, I need these data for this purpose. The others should share them with them, and then they can say on a sort of ad hoc basis, yes, these are the conditions, do it, bam, right? That is sort of my way out of that. I always think of, just sort of to add that quickly, I always think of the patent cases on a friend basis, where you share patent information on a basis of fair, reasonable, non-discriminatory. But even there, we see that it's so incredible to put into practice that therefore we need a quick adjudication system.
Okay, it looks like fines are not enough because they're becoming something of habit and not not efficient on the ground in Olga's view. Thank you, Olga, for intervening, and thank you for your comments. And I guess we are perfectly on time. Maybe we have time for one last question, if there is any from the audience.
May I? Your question about the algorithm.
Luigi Camella, I'm not sure who is intervening. Maybe Luigi.
I'm Olga. You firstly asked the professor about how can we instruct the algorithm, and the answer wasn't offered to us.
Wasn't given. Okay, but before replying to that tricky question, and I would like also to give allow Luigi Crimella, if I am correct, I think I heard his voice. Luigi, was it you to ask a question? Luigi? No, it wasn't you.
It was me, I guess, from Antonio.
Antonio, sorry.
Okay.
Do you want to ask it?
Is there time to ask for the question?
Very quick question.
Okay.
Sure.
Yes. No, that's what. It's very interesting. Thank you very much for your lesson. It was very interesting. And the one thing that you outlined the market investigation power as very different for the competition prohibition, the general competition prohibitions. But you say that basically when the CMA looked if there was in the BAA case an adverse effect on competition, just it's completely different than, for example, an abuse of dominant position. My question is that, but if in the law, for example, if I remember well, is the Enterprise Act 2002 defining the market investigation powers. There is, they say that the authority can check whether there is an adverse effect of competition, and if there is, in case there is an adverse effect of competition, can impose some remedies. Is that very different from checking where there was an abuse of dominant position and then imposing remedies? I mean, the adverse effect of competition could be much wider, of course, concept, but can become a legal concept after some case law as the abuse of dominant position. I mean, in economics, dominant position can mean something, but as you well know, I mean, the case law could be something different, and the abuse of dominant position is something that's been defined by case law in time. So cannot be the same happening for the adverse effect on competition and then the remedies to be imposed by a competition authority.
Yeah, very good point, Antonio. I think that what you said is what is essential is that, as you say, it's so vague that we sort of both on the level of violation and on the level of sanction. And this is exactly the vagueness that we also want, because we don't want to sort of focus again within a couple of years on sort of it has to be like this and the standard that has to be met like that, etc. And that is why, that is sort of the mechanism to ensure that is that the courts are not allowed to look into substance in this legal system. So they can see whether the procedures, etc., were right, but they are not. There's no substantive legal control by the courts, which would give the Commission an enormous leeway. And so, yes, I agree with you. It may sort of come to a certain standard within a couple of years, as is typically the case with legal issues, as you say. But in this case, the whole idea is to avoid exactly sort of this binding of the Commission, and they will probably find mechanisms to work around that. One is by not involving the courts anymore to this degree, and the second would be to sort of use words that are so vague that, I mean, adverse effects of competition, that it can sort of be taken for that. And obviously they would also not have so many cases. I mean, if you want a concept like abuse of dominance, you need a couple of cases. So as you say, the proceeding of what is it is developed over years and years. And if you have only, say, 1 or 2 cases running in 3 years' time, that probably makes it more difficult. But in the way of legal theory, in a legal theory way,
yeah,
actually,
it's hard. It's pretty hard in terms of legal theory. Yes, okay. So we're going to see whether, let's say, the rule of law would still exist in a few years' time, whether conditionality under which we want the countries, Eastern countries, to submit themselves to the rule of law would still apply to us in terms of competition law. So what would hold for others will not hold for the competition law realm, but still I'm confident that we will find our way out of this mess. And apart from that, I clap to this beautiful presentation, and I hope we will find a way also to actually establish whether we will have a digital single act, a digital market act, and a new competition tool or whatever it will be, because we should also consider that we also have the European Parliament and the European Commission fighting over what they are going to do with the artificial intelligence white paper, and that there are so many overlapping initiatives there. So I thank you so much, Rupprecht, for being with us tonight and for providing us with this excellent presentation. And I thank you all the students and participants in tonight's class. And I see you next time. Bye-bye.
Thank you.